The Home Office does not care how much you want to come to the UK. It does not care how much money you spent preparing your application. It does not care that you planned your life around this visa. It cares about one thing only. Does your application prove beyond doubt that you meet every single requirement in the immigration rules? If it does not, your application gets refused. And in 2026, refusal rates have increased. Processing has become more stringent. Document verification is more sophisticated. And a deception finding, even an accidental one, can trigger a 10-year reapplication ban that ends your chances of ever coming to the UK. The 5 reasons the Home Office refuses more applications than any other in 2026 are not complicated, but thousands of people are getting them wrong right now. This video tells you exactly what they are and exactly how to avoid every single one. Every year, the UK Visas and Immigration Directorate processes millions of applications. Visitor visas, skilled worker visas, student visas, family visas, settlement applications, extension requests, and every year, a significant proportion of those applications are refused. Not because the applicants are ineligible, not because they are lying, but because they made avoidable mistakes in how they prepared and presented their case. In 2026, the stakes are higher than ever. The Home Office has intensified document verification procedures. Financial evidence scrutiny has become more rigorous. The English language requirements have been raised for some routes. New salary compliance rules have been introduced for skilled workers. And the overall immigration environment is more restrictive than it has been in a generation. A refusal now is not just a setback. It goes on your immigration history permanently. Every future application you make anywhere in the world will ask whether you have previously been refused a visa. For some route refusals, there is no right of appeal. You cannot challenge the decision. You can only reapply and hope you get it right the second time. Understanding why applications fail is not an optional extra. It is the foundation of every successful immigration application in 2026. This video covers the 5 most common reasons the Home Office refuses visa applications right now, what the exact legal basis for each refusal is, and what you must do to ensure your application does not become another statistic. The first and most widespread reason the Home Office refuses applications in 2026 is financial evidence failure. This is the single biggest category of refusal across virtually every visa route, and it comes in multiple forms, each of which the Home Office will identify and act on. The first form is insufficient funds. Every visa route has specific financial requirements. For a visitor visa, you must demonstrate that you have enough money to cover all costs during your stay in the UK without working or accessing public funds. For a skilled worker visa, the salary must meet the applicable general threshold and the going rate for the specific occupation. For a spouse or partner visa, the UK sponsor must demonstrate income of at least $29,000 per year as of April 2024. For a student visa, applicants must hold the full course fees for the first year, plus maintenance funds of $1,023 per month for studies in London or $820 per month outside London, held for at least 28 consecutive days. If the funds in your bank account on the closing date of the 28-day period are below the required total, your application will be refused. The second form of financial evidence failure is unexplained large deposits. This is one of the most common and most avoidable causes of refusal. Caseworkers are specifically trained to look for sudden large deposits that appear in bank statements shortly before an application is submitted. These deposits raise the question of whether the funds are genuinely yours or whether they have been temporarily transferred into your account from elsewhere to make your balance look higher than it actually is. The Home Office calls this borrowed funds, and it is treated as evidence that your actual financial position does not meet the requirements. To avoid this, never make a large cash deposit into your account in the weeks before your application. If you have received a legitimate large payment, such as a sale of property, a bonus payment, or a gift, you must provide documentary evidence of the source of that money alongside your bank statements. The third form is using bank statements that are incomplete, altered, or inconsistent. Bank statements must show your name, account number, bank logo, full transaction history, and current balance. They must be official documents from the bank, either original printouts or certified copies. Any alterations, redactions, or inconsistencies will be treated as fraud and can result not just in a refusal, but in a deception finding with a 10-year reapplication ban. The second major reason the Home Office refuses applications is documentation failure in the broader sense. This covers missing documents, incorrectly certified documents, poorly organized submissions, and documents that contradict each other within the same application. The immigration rules for each visa route specify a list of required documents. UKVI publishes supporting document guidance for each route, and caseworkers use this guidance as a checklist when assessing applications. If a document on that list is absent, the caseworker will not contact you to ask for it. They will simply note the absence as a failure to meet the requirements and issue a refusal. Missing a single document from a long list is enough to refuse an entire application. This is a critically important principle to understand. The Home Office does not chase missing evidence. The burden of proof is entirely on the applicant. Every translation must be certified. Where a document is not in English or Welsh, a certified translation by a professional translator must be provided alongside the original. Documents that have not been properly translated will be disregarded. Inconsistencies between documents within the same application are particularly dangerous. If your employment letter states a different salary to your payslips, if your bank statements show a different account number to the one on your financial summary form, if your sponsor letter gives different dates to your itinerary, caseworkers will interpret these inconsistencies as evidence of unreliability, inaccuracy, or deception. Organizing your application so that every document corroborates every other document is not just good practice, it is essential. The third major cause of refusal in 2026 is failure to demonstrate genuine intent. And this applies most directly to visitor visa applications, but also influences assessments across multiple route types. Every visitor visa application is assessed against the question of whether the applicant is a genuine visitor who will leave the UK at the end of their permitted stay. Caseworkers are given detailed guidance in the Appendix 5 visitor rules and the accompanying visitor guidance on what factors to weigh when assessing genuineness. The factors that most commonly lead to refusal under this category are weak ties to the home country, an unclear or vague purpose of visit, and a pattern of travel history that suggests an intention to remain in the UK permanently or work illegally. Weak ties to the home country are the most common. Ties include stable employment, property ownership, ongoing studies, family responsibilities, and any other circumstance that gives the applicant a concrete reason to return after their visit. A visitor who is unemployed, has no property, has no family dependents, and has applied for a long stay with a vague purpose will almost always be refused. The purpose of the visit must be clearly articulated and supported by evidence. If you are visiting for tourism, provide a detailed itinerary. If you are visiting for business, provide a letter from your employer confirming your role, the specific business purpose, and that your salary will continue during the visit. If you are attending a conference, provide the conference program and your booking confirmation. Vague statements such as, "I want to see the UK" or "I am visiting friends" are not sufficient. The fourth major cause of refusal is immigration history issues, and this is an area where many applicants inadvertently damage their own case by failing to understand what must be disclosed and how it will be interpreted. The Home Office has access to a wide range of immigration data from UK and international sources. Any previous visa refusal anywhere in the world, any overstay in the UK or any other country, any breach of visa conditions such as working without permission, and any criminal record must be disclosed truthfully and fully. Failure to disclose is treated as deception under Part 9 of the Immigration Rules. Deception findings carry mandatory or discretionary consequences depending on the severity. A finding of deception or false representation typically results in a 10-year entry ban. Even where a previous breach was minor, such as a brief overstay years ago, the failure to disclose it is treated as more serious than the breach itself. When disclosing past issues, provide a clear, honest, and concise written explanation of the circumstances, confirm what has changed since then, and provide documentary evidence of those changes. A previous overstay explained honestly alongside evidence of strong subsequent compliance is significantly more favorably assessed than an undisclosed overstay discovered by the caseworker during their checks. With the enhanced data sharing arrangements between UKVI and international immigration authorities that have developed since 2020, the probability of the Home Office discovering an undisclosed breach has never been higher. The fifth major cause of refusal in 2026 is what can broadly be described as suitability failures under Part 9 of the Immigration Rules. Part 9 contains the general grounds of refusal that apply across all visa categories. Some are mandatory, meaning the Home Office must refuse if the ground is met. Others are discretionary, meaning the Home Office may refuse depending on the circumstances. The mandatory grounds include criminal convictions resulting in a sentence of 12 months or more, the use of deception in any previous visa application, and being the subject of a deportation order. The discretionary grounds include a wide range of conduct issues such as non-compliance with previous visa conditions, failure to pay NHS charges, failure to pay litigation costs awarded against the Home Secretary, and concerns about character conduct or associations. In 2026, with the Sentencing Act 2026 having come into force on 22 March 2026, suspended sentences of 12 months or more now trigger automatic deportation liability for foreign nationals, which creates new mandatory suitability grounds that were not previously in effect. Additionally, UKVI is applying suitability checks more robustly under the broader immigration enforcement focus of the current government. Applicants who have had any interaction with the UK's benefit system in ways that were not authorized under their visa conditions, applicants with outstanding NHS debts, and applicants whose previous visa compliance was imperfect are facing higher rates of suitability-based refusal in 2026 than in previous years. What should you do now if you are preparing a UK visa application? The first action is to obtain and carefully read the official supporting documents guide for your specific visa route on the Gov UK website before you begin gathering evidence. This guide lists every document UKVI requires and is updated regularly. Using it as a literal checklist is the most reliable way to ensure you have not missed anything. The second action is to have your bank statements professionally reviewed before submission. Look for any unexplained large deposits, any periods of low balance, any inconsistencies in transaction descriptions, and any gaps in the statement period. If any of these exist, prepare a written explanation with supporting documentary evidence. The third action is to have every document cross-checked against every other document before submission. Names, passport numbers, dates, salary figures, and account numbers must be consistent across the entire application. A single inconsistency can undermine an otherwise strong case. The fourth action is to be proactive about your immigration history. List every visa application you have ever made anywhere in the world. List the outcome of each one. If any were refused, gather the refusal letters. If you ever overstayed anywhere, prepare a written explanation. Disclosure is always safer than non-disclosure. The fifth action is to instruct a regulated UK immigration solicitor if your case involves any complexity, any previous refusal or overstay, or any unusual financial circumstances. The application fee alone for a skilled worker visa is over $1,000, and the immigration health surcharge adds thousands more. The cost of professional legal advice is small compared to the cost of a refusal, a reapplication, and potentially a 10-year ban. The Home Office refuses visa applications every day for reasons that were entirely preventable. Avoidable document gaps, unexplained bank deposits, vague visit purposes, undisclosed overstays, salary inconsistencies. These are not difficult problems to fix, but they are very easy problems to overlook when you are preparing an application without understanding exactly what caseworkers are looking for. In 2026, with processing scrutiny at its most intense in years, the margin for error is smaller than it has ever been. The 5 reasons covered in this video are responsible for the majority of refused applications. Understanding them is the first step to ensuring your application is not among them. Share this video with every person in your network who is planning a UK visa application. The information in this video could save them from a refusal that follows them for years. Leave your questions in the comments below. Subscribe to this channel for every update on UK visa rules and best practice throughout 2026. Get your application right the first time. You cannot afford not to.